if you're the beneficiary for a work visa, just recently you had this consult, right, John, last week, with the lady, and she was arguing with her employer's
Yeah.
attorneys. Yeah, can you elaborate on that? It was very interesting, like case.
Yeah, it's a little bit of different fact pattern, but like essentially this person is getting a green card and her family is overseas. And she has to go through a certain process to be able to bring the family here, but there's a time limitation. There's a 1 year time limitation. And she, she works at one of the most famous companies in the world, and they have one of the most famous immigration firms in the world helping them. And their lawyers are making a mistake saying we can't help the daughters until like your green card is fully approved. But that would delay things so much that the daughters would age out, be too old to be a part of our application. But they're making an error, not reading the policy. So in these kind of cases, you got to take control of your case. Now, for employment-based green card cases, the first step or two the employer does, the perma process and the I-140 for that kind of case. But the adjustment of status phase is something the applicant can do on their own, but they need the paperwork. They need the I-140 approval notice. They may need the employer to sign I-485J. So their involvement's needed, but they also need the basic paperwork too. And so a lot of times you see what's going on by doing these FOIA requests behind the scenes, just to have a backup of everything to keep an eye out. And it's, again, I can't recommend it enough. If your employer is hiring the lawyer for adjustment of status, that firm essentially is primarily, although both of you could be clients and there's a conflict of interest and ethics issue that's very complex in immigration law, it really would be wise for you to get individual consultation on your case, if at least a consultation with a couple of attorneys, so they can review the situation, guide you, because those attorneys usually do, those big companies have anywhere like 1,000 clients at one time, whereas we'll have a fraction of that. So we have the ability to give more individual attention. That's the whole focus of a boutique small immigration firm as compared to behemoths. Now, my friends work there. I have them on my podcast. I have a different show that I have them on. They're good people. They fit they're a special tool for a special thing. When you have a company that needs to do 10,000 applications, we can't do 10,000 applications. Now, maybe 20 years from now, who knows? But right now, our goal is to focus one-on-one kind of stuff, that relationship, or maybe 10 or something like that. But so we need those people. But when you have 10,000 applications, you're just 1 out of 10,000, so you get the attention you need. So it's really good to have your individual lawyer on the adjustment of status phase, look over things, to talk with you, and to potentially do that FOIA request to see what happened in the application process, what was said, so you have that paper trail if you need it.
Yeah, I want to bring this other case too that we encounter. So basically, the family, they applied for green card. I mean, not they, but again, their employer applied for their work green card. And the attorneys, they were just in charge of the work petition itself. They did an excellent job. Everything got approved. No problem. Perm process. Who went through this know how complicated and lengthy it is. But the attorneys, they didn't. I don't know. They didn't pay attention. It wasn't part of their work to go over the actual adjustment part, because they didn't even tell the people that they cannot adjust in the United States. So what's the point of having the approval of your work green card if you cannot adjust status in the United States? So these are the details, and these things are like really terrifying. And like I feel so bad for these poor clients,
they're hopeful,
they're able to catch it like 2 years after the fact.
And the employer paid all this money for no reason, because these people had inadmissibility issues. Not inadmissibility, but for adjustment of status, you have to maintain valid status until the time you file Form I-485. In this case, without going too much detail, they had something that kept them here legally, but not enough for adjustment of status. And so they went through the whole I-140, whole perm, all that work green card process, and they got to adjustment. And the firm's like, we only hyper focus on these. We do 1 million of these a year. We don't do anything else. And anything that's a little bit different, we don't know. So as soon as it came to me within the first email, I'm like, well, that's not happening. And so it's like, well, they should have just told you and stopped the process. I don't think they intentionally did it to take money. I just think they're so hyper-focused on the one thing that they do that they lost track of things. Thank you for watching this educational program. To get the latest videos, click the subscribe button and the notification bell icon. Also, help us help the immigrant community by liking this video and sharing it with your family and friends. You can also find us on other social media sites like Instagram, Facebook, TikTok, LinkedIn, and Twitter, where you find the latest updates on immigration news, policy changes, and tips. Be safe and God bless. See you soon.